Now, during the time of Mr. Lucky's termination, you understood that Mr. Gladney was his supervisor, right?
Objection, Foundation.
Do you not know that?
I'll allow it if she can answer.
Thank you, Your Honor.
At the time of the PRB hearing? The termination hearing?
The discussion with the sheriff in which the decision was made to terminate Mr. Lucky.
I don't recall if he was his supervisor at that time or not.
Okay. Do you recall knowing at any time if Mr. Gladney was both Mr. Lucky's supervisor and the union president?
Yes, I believe he was. He was definitely the union president throughout Mr. Lucky's entire career. And Mr. Lucky did work out at patrol, and that's where former Sergeant Gladney was working for a while.
Okay. Now, what if Sergeant, as union president, Sergeant Gladney thought that, hey, let's say had an opinion that came in conflict with his supervisory duties? What is should his response be?
If what?
If Mr. Gladney had a conflict with his role as union president and his role as supervisor, which role supersedes?
I have no idea what the union rules are for their president.
Great. What are the employment rules?
We don't have any employment rules that dictate who can be a union president and a supervisor.
Okay. Do you have rules about what happens if somebody gets conflicting information on an order?
If somebody who's on an order is confused by the information on the order?
All right. So let's say somebody directs Sergeant Gladney to do something to Mr. Lucky. I'm going to say Mr. Gladney just wants to discipline Mr. Lucky. Right? His role as supervisor trumps his role as union president as far as your employment power is concerned, right?
Well, the union president needs to stay out of the workplace. So I don't, I can't answer that question.
Well, if the union president's role needs to stay out of the workplace, that means that in the workplace, the supervisor role trumps, right?
We don't consider a union president to have a vice president or a trustee to be part of, your day-to-day job duties. So he would be supervising him as a Milwaukee County Sheriff's sergeant, not as a union president.
And so the county doesn't have any.
What? You're fading out.
I think he's frozen. I can't see him moving or hear anything.
Right. I think because there's so many people on the line, we're having some connection issues.
I'll try again. I can also, maybe at the next break, I'll log in and out too. Does seem to be mostly on my end. And I apologize, but I'll ask this question again. The county does not have disciplinary jurisdiction over union matters, right?
Right.
Okay. But the county disciplined Mr. Gladney for calling Mr. Lucky nigger and threatening to assault him, right?
I believe so, but I mean, for his, for what he did, I don't recall it having anything to do with him being the union president.
Great. And in fact, necessarily it couldn't have anything to do with him being the union president if the county disciplined him for it, right?
Right.
Right. Sky is green, Judge. Sky is green. If we're able to take a break, I would appreciate it.
How much time are you thinking?
Just 5 10, just for hydration and bottle
Okay.
purposes here.
It is 3 o'clock, 2 minutes to 3. So let's break until 3:10.
Eventually that has to happen.
All right, are we ready to continue?
Okay. Okay. Now, what steps did your office take to investigate Mr. Lucky's race discrimination claims?
Objection vague.
Fair enough. I can rephrase that, and I'll do it like this. His race discrimination complaints that he made to Internal Affairs.
I don't recall the specifics about the case, but I do recall a case was opened and investigated.
Okay. And what did you do to investigate the, I guess let me put this another way. What is, let's another way. Is a supervisor calling a subordinate employee nigger, is that a terminatable offense?
Is that what?
Objection.
Does the county terminate sheriff's department terminate employees for using racist epithets at subordinates?
It could be, depending on the facts of the case and what's determined to be found.
Okay, and the county's in fact done that, hasn't it?
I don't recall anybody being terminated.
Well, how about the Stephen Artist case?
I recall he was terminated, but I don't recall the specifics about his case.
Okay, was he alleged to have made a racially insensitive comment about a subordinate employee or something else?
You know what? I don't recall. I don't investigate the cases. That's not my full responsibility. I
No,
sign off on them as we've established when they are come to me, but I don't, the person to ask would be the investigator on that.
But you sign off on the investigation, right?
Well, the beginning part of it, yes. When it comes, or if we are going to open one, yes.
And after the investigation happens, you sign off on that, right?
I don't sign off on it, I just read the
You
case.
make sure it's complete, right?
But again, don't recall the specifics of that case. If you want to show me the case, then I could probably testify about it, but don't recall it.
So you'll dispute that it's the county's general policy to terminate supervisors who hurl racial epithets at subordinate employees.
I think I already answered that, that just all cases are different. They stand on their own 2 feet. They all have their different facts.
Oh, okay. And how about threatening to assault a subordinate employee? Would that result in termination?
It depends on the facts of the case and what comes out during the investigation.
And that's one of those, progressive discipline is exempted in those situations, right?
Again, it depends on what comes out in the facts of any given case. Some cases go right to termination, some have progressive discipline. Some of them, the facts aren't always what you thought they were in the beginning. That's why investigations are done. So every case is case by case.
Do you remember any case in the last 3 years in which, except for Mr. Gladney's, in which the sheriff's department did not terminate a supervisor for making a racist comment at a subordinate?
I would have to look through the cases to refresh my recollection, sir.
So no. Sitting here today, you don't recall any. Is that right?
Yeah, I can't answer that. I do not know.
Okay. And in fact, Mr. Gladney only did a 10-day suspension, right?
I don't recall what his was. If that's what you're telling me it was.
Okay. Let's talk about some other department disciplines. How about Captain Hanna? Do you know who he is?
Yes, I do.
Okay. And the department suspended him for 30 days after you approved those charges too, right?
I don't recall exactly what the days of his suspension were, but I do recall that there was a suspension recommendation for him.
Okay. Did you do anything remotely like calling a subordinate employee a nigger?
Your Honor, objection, this is far afield from the scope of your order.
Right,
It
where
has
are we
nothing to do
going?
with this case.
Yeah, where are you going with this, Mr. or Attorney Cross?
Comparing the discipline for Mr. Gladney against other disciplines.
Which she just,
Okay,
and I'd like to add.
Every discipline's different, but she can't state a single example of one that's different.
okay. So that's her answer.
Okay. Just on that note, well, for a second here, I believe we'll try to sneak in Mr. Smoot after this, just as a heads up. Okay. Do you believe that Danita Ball knows that Mr. Lucky filed an ERD complaint prior to, or that you knew that Mr. Lucky filed an ERD complaint prior to signing off on the investigation to her?
I have no idea what Danita Ball knew about anything related to this.
Have you ever told her
Ever told her what?
that you knew that Mr. Lucky filed an ERD complaint prior to sending off the recommendation for his termination?
Well, first of all, I think I said I don't recall, and second of all, I don't recall ever talking to her about it.
Okay. Do you recall when you sent the complaint from to Ms. Ball?
I don't recall if I did or I didn't.
Well, who else can send a complaint to Ms. Ball?
What kind of complaint? An ERD complaint?
No. The complaint against Mr. Lucky that resulted in his termination that you sent to her as after checking it for completeness.
You have to ask the question again.
Have you ever told Danita Ball that you were aware of Mr. Lucky filing an ERD complaint when you sent it after you checked it for completeness, but before you sent it to her?
Well, again, I don't recall knowing that, and I don't recall discussing anything about an ERD complaint with her.
Okay, but again, you don't dispute Ms. Paul's notes that says when she said that she told you prior to that, you signing off on these charges, right?
I wouldn't dispute what Mary's. I would have no reason to know what Mary is saying. I mean, because it's
Okay.
what Mary said.
And which do you think is more valuable? A contemporaneous note that's written down or somebody not remembering something?
The note that the person who wrote it is going to testify to as to it. I keep telling you what I can and cannot remember. And, you know, instead of trying to refresh my recollection, you accuse me of trying to be evasive. So if your questions were better and you could, you know, show me things, it might be more helpful for this entire process.
Okay. So I'll share with you Mary Paul's notes. So we can see that there. Can you see it?
Yep. Which date are we referring to? All of
We're
them?
gonna go through them all. August 14th, 2021. Deputy Lucky filed a complaint with Internal Affairs against Sergeant Gladney due to an alleged threat he had received. That's a true statement, isn't it?
I don't know if that's a true. I don't have any recollection of these dates that Mary wrote down. Like I've been saying, obviously, if Mary can testify as to what she wrote, then that's what she will testify to. I have no recollection of on August 14th, if that's when he filed a complaint with Internal Affairs against
Okay.
Sergeant Gladney. That's all
I
I'm
appreciate
saying. Does that make sense to you?
Sure. So sitting here today, do you have any evidence that on August 14th, 2021, Mr. Lucky did not file a complaint with Internal Affairs against Sergeant Gladney?
No, I don't.
Okay,
I do not.
Do
I
you have any-
keep just telling you I don't recall.
great. Sitting here today, do you have any evidence that on August 14th, 2021, that Mr. Lucky did not call Mr. Gladney for something union related, which led to Gladney allegedly making threats?
Absolutely not.
Okay. Sitting here today, do you have any evidence that on August 14th, 2021, Mr. Lucky did not record the conversation?
That he did not record do I have any evidence that he did not record the conversation?
You got it.
No,
Okay. And in fact, you have independent recollection that he did record the conversation, don't you?
I don't have any recollection of that.
Oh, okay. But you signed off on those charges, didn't you? The investigation.
Objection vague.
Yeah, but 2 years ago.
Okay. Things that happened 2 years ago, do you believe that those existed or don't exist?
Again, I don't recall what happened on August 14th, 2021, as it relates to what is said here.
Great. Sitting here today, do you have any evidence that on August 16th, 2021, Lucky and Gladney were not ordered to not have contact with each other unless in passing or absolutely necessary?
No, of course
No.
not.
Do you have any evidence that an IA case was not open on both of them?
No, I don't have any evidence. I have no reason to doubt what is said here. We've already covered this.
You have independent knowledge that an IA case was open on both of them because you approved that IA case being open on both of them, correct?
If an IA case was open, yes, I approved it. And we all know
Right, you
that
told,
cases were open.
or somebody else from your office told Ms. Paul on August 16th, 2021 of that fact, right?
Absolutely, it could have been somebody else.
Okay. Sitting here today, you have no evidence that Mr. Lucky felt safe at work on August 18th, 2021, right?
Say that again?
You have no evidence sitting here today that on August 18th, 2021, that Mr. Lucky felt safe at work.
I don't know either way, but he's stating here that's what he told Mary, or he told Sergeant Baker, who Mary's notes.
Okay. You don't have any evidence sitting here today that you didn't meet with Captain Holton, Captain Novotny, and Mary Paul at 1:30 on August 18th, 2021 to discuss next steps in regards to Mr. Lucky's complaint, do you?
Again, I have no independent recollection of it. I have no reason to doubt that we met, but I have no independent recollection of that meeting.
You have no knowledge of whether, or sorry, you have no evidence here today that Ms. Paul did not meet with Mr. Lucky virtually via Teams at 3:30 on August 18th of 2021. Is that right?
I don't have any information about that at all. Correct.
Okay.
Independent.
And you signed, excuse me. And you signed an affidavit about your knowledge of, specific knowledge of recording practices and the recording of this meeting, right?
Of this meeting?
Right. The meeting with Molly, Captain Holton, Captain Novotny, and Ms. Paul.
Objection, the document speaks for itself.
I think his question was, does she have any knowledge?
I've never recorded a meeting before. I've never known any Teams meetings to be ever recorded. I have no knowledge that that was recorded.
So it's your testimony today that you have no knowledge that it was recorded, not that you have specific knowledge that it was not recorded. Is that true?
I did not record that because I never record any.
Okay, and you have specific knowledge of that. Is that right?
Well, I would know if I have recorded any Teams meeting ever, and I've never in my entire history of working here have I recorded any of my Teams meetings.
Okay, and would you have knowledge of having the fact that Mr. Lucky had, let's put it another way, how many employees have been walked out the day after Internal Affairs starts collecting documents on their equal rights complaints, to your knowledge?
I don't know. All I know is employees are, if the recommendation from the sheriff's termination, they are walked out that day when the sheriff decides. But as far as timing with other things going on, I don't know.
Okay. But again, you specifically recall that you don't record any Teams meetings ever, right?
I don't what?
You specifically recall that you don't record any Teams meetings ever, right?
I have never recorded any of my team's meetings.
Okay. And that's in contradistinction to your recollection of Mr. Lucky's ERD complaint, for example, right?
I don't understand your question.
Contradistinction, is that possibly the issue?
No, I don't understand what your question is. Because I can remember I don't record Teams meetings?
Right. I'm comparing those, we can compare and contrast
I didn't
your
even know you could.
recollection of Teams meetings with your recollection of, for example, whether or not Mr. Lucky filed an ERD complaint prior to your signing off on the investigation that leads to his termination, right?
The reason I know I have never recorded a Teams meeting is because I never even knew you could record a Teams meeting until this came up. So.
Oh, okay. And you also know that without providing people information, the sheriff, the supposed decision maker about whether or not somebody files an ERD complaint, that they can't possibly make a determination about whether it's retaliation or not, right?
Objection argumentative.
Yeah, it sure is.
I'm gonna allow it.
Again, the cases before the sheriff are on the facts of the case that are before him. So I would disagree with you. As I've said twice already.
Can you help me understand why you disagree with me?
Well, like I've said before, the cases that the sheriff hears are focused on that case. And the decision the sheriff is making is on that particular case before him.
Hey, I know another one. Did you tell the sheriff that the union refused to represent Mr. Lucky?
I don't recall anything about that at all.
How about the PRB? Did you write them a letter saying the reason Mr. Lucky's having trouble getting attorney is because Frederick Gladney called him a nigger and now the union won't represent him?
Did I send a letter like that? No, I did not.
Yeah. Okay.
I would have recalled sending a letter to the PRB.
You have a close working relationship with the Corporation Counsel with regard to the PRB, don't you?
The Corporation Counsel represents the sheriff's office like they do every other department with cases before the PRB.
Well, in fact, the Corporation Counsel's office came to you to ask to have members of the personnel, the PRB removed, didn't they?
I don't recall that.
In the Hanna case, you don't recall that the president and the vice president of the PRB were removed?
I know they were, or I think just the president was, but I don't recall being involved in that decision.
And you deny that Miss
That's not your question. You said that I was involved in that.
What was my question?
You asked if I was involved in that. And I don't recall being involved in that.
I would also object that the Hannah case, once again, not relevant to this case.
Do you deny that Katie West emailed you about the PRB members and requested that you talk to the members of the county in her behalf?
again, I'm not denying anything. I don't recall being involved with that.
You deny that there's emails from Katie West to you about removing members of the PRB in the Hannah case?
Again, I said, I'm not denying that. I said, I don't recall that.
Do you recall acting on those emails?
Again, Your Honor.
Why-
Thank you.
Yeah, why are we talking about someone else's case, Attorney Cross? How is this?
Well, if she's able to get members of the PRB removed on behalf of the corporation counsel, and she's not denying that she did that,
Yeah,
that,
You know what?
excuse me, then that also speaks to her relationship with the PRB, the eventual decision makers, and the possible reasons why she did not. I mean, we're in cat's paw here. So the issue is all about what information she restricted and gatekept from the PRB and the sheriff. So it's the same information from the sheriff that we went into in great detail. Now we're talking about the PRB, and apparently she's got the ability on behalf of the corporation counsel to have members of the PRB removed when she doesn't like the outcome.
Okay,
So that's what I'm asking is, what is her relationship with the PRB?
all right, but we're not even talking about the ultimate discharge in this case, in the PRB.
Absolutely agree. It's the question is now it's this person here is the, I mean, I dispute that, but I agree that that's the ruling. I'm saying that this person here has a part of the issue, and part of what we're going into is what did they tell the ultimate decision maker about his ERD complaints?
Your Honor, we haven't gone into how the PRB is formed, operated, who appoints them, and who they respond to. We have none of that evidence on the record, and I would argue that I'd ask that counsel's inflammatory statements as to what may or may not have occurred in another case be stricken from this record.
Uh,
I mean, there's no
Attorney.
basis. There's no
Yeah.
basis.
There's emails. There's emails.
Okay. All right, I'm not interested in what she may or may not have done in another case as it relates to the PRB, because that issue is not in front of me. So I'd like to move on from here.
Okay. Well, do you have direct communications with any members of the PRB, Ms. Zillig?
I do not.
Hmm. If the county, if you're not satisfied with the decision that the PRB makes, who do you go to?
The department has the ability to appeal a PRB decision just like an employee does. So most likely we would appeal that by writ of certiorari or direct appeal to the court.
Okay. Okay. Now, there's this meeting in which the sheriff decided he didn't tell about the fact that Mr. Lucky complained about the IA complaints or his.
It's breaking up. I don't know if anybody else is, but mine is.
Can't hear it either.
I'm sorry.
We could not understand you because you were breaking up.
I'm happy to repeat it.
Please.
I got that Mr. Navani gave me that hint that it wasn't, that he was stupid, and because I was saying it slower. And so now I'm trying to keep that in mind and just repeat myself here. It's just, it's It's one of the burdens of being over the internet as opposed to in person here. But we'll see what we can do. Based on just talking here, are you able to hear me now?
Yes.
Great. Let's do that. So, yeah. Mr. Lucas, did you ever tell him that Mr. Lucky filed an ERD complaint?
I don't recall.
Okay. Did you ever tell Mr. Lucas that Mr. Lucky said that Internal Affairs discriminates, retaliates against him?
I don't recall either way.
Okay. Did you ever tell Sheriff Lucas that Mr. Lucky made race-based complaints?
I don't recall.
Okay. How about Chief Deputy Ball? Did you ever tell her that he made race-based complaints?
I do not recall that.
Okay. How about complaints about Internal Affairs?
I don't recall that.
Okay. How about the ERD?
I don't recall that.
Okay. Now, sitting here today, do you have any evidence to dispute the Ms. Paul's notes that says that Lucky sent a complaint to Ms. Paul via email and requested a meeting? He was always already forwarded me a billing issue with EAP.
No, I have nothing, no evidence to dispute that.
Okay. How about that you discussed the complaint and reviewed it with Captain Novotny and Ms. Paul on August 30th of 2021?
Objection vague.
Okay, do you have any evidence sitting here today to dispute that on August 30th of 2021 that you received and reviewed a complaint with Ms. Paul and Captain Novotny?
Objection vague.
What's vague about that?
What
Maybe
complaint are you talking about? Who did he say a complaint he sent to who?
This is, I
There's
believe.
multiple complaints at issue.
Fair enough. I thought we had gone over this so many times, but it's my understanding that this is the HR complaint with Mr. Glad.
That he emailed to Mary Paul on August 30th. Is that your question?
August 29th, and that Ms. Paul went over this with you on the 30th. Do you have any evidence to dispute that she went over this HR complaint with you on the 30th?
I have personally no evidence. I don't.
Okay. And then again, you have no evidence here to dispute that on August 31st of 2021, that Ms. Paul informed you that Lucky made an ERD complaint.
Is that what that said on there? I recall reading what you just showed me, but I don't recall that being on that.
Okay.
Yeah, you didn't show me that one.
Okay. You see this here? Called Lucky at 11 o'clock. He informed me that he mailed a complaint to ERD. Did you see that?
Yeah, but I don't see her saying that she told me that.
Right. If you'll just go down to the bottom there. Do you see it now?
Yeah.
Okay. So just for the record, you admit that she says that she followed up with Molly on the conversation and they hear Molly.
Yeah. I mean, I have no reason I don't have any evidence to say either way. If that's what she testified to, like I said, I don't recall.
Okay. And you don't have any evidence to dispute the fact that Mr. Lucky, and that she followed up with you on the fact that Mr. Lucky believes that IA cases were actually being investigated, he wouldn't have been suspended in the past. You see that there?
Say that again? What?
You do not have any evidence to dispute that she.
Yeah. I see that. Yeah, that's what he told her. Yep. I don't have any reason to dispute that he told her that.
Fantastic. And you'll agree with me, I'm sure, that his statement saying that if IA cases were actually investigated, he wouldn't have been suspended in the past is another way of saying retaliation for filing internal affairs complaints, right?
I don't know what he meant by that. I know that that's whatever this says is what Mary wrote down, but I don't know.
Okay. And do you have any knowledge to dispute the fact that he's making a race-based complaint here?
Do I what?
Do you have any evidence to dispute that Mr. Lucky is making a race-based complaint at this time?
This ERD case that we're on this phone call about?
No, the HR complaint. Thanks for that clarification.
Oh, I don't recall what it was specifically about, other than what I'm reading here, because you're thankfully giving me something to read.
Okay. You see where it says he doesn't believe that it's fair that he's being victimized?
Yes.
Okay, and that's in connection with his complaint that he's being called a nigger, right?
I don't know, because it doesn't say that here. Mary could probably answer that better.
Okay, and you see at the bottom it says, I again emphasized whether or not he felt safe at work. Do you see that?
Yep.
Okay, and that's again emphasized, right? Because that's relating back to the previous conversation she had with him right after she talked with you, right?
I mean, it could be. I'm just reading this. It could have been about other things. I don't know. I don't know what, and again, Mary could answer. She had the conversation with him.
Okay, and do you have any evidence to dispute that you and Ms. Paul on September 2nd, that Mr. Lucky's internal affairs interview is now scheduled for September 3rd?
I have no reason to dispute that, but I don't have an independent recollection of when it was.
Okay. And just to be clear, September 3rd is 4 days after you learn that he's got this ERD complaint, right?
I believe so, yeah.
Okay.
I mean, again, I don't have a recollection of, this, but I have no reason to doubt what Mary wrote here.
Okay, and it's also, well, and you wouldn't have, if Ms. Paul testified that on September 15th that she was collecting documents at the request of Ms. Lawrence here and giving them to Mary Yu, would you dispute that?
No, but again, I have no independent recollection of it.
Okay. And again, you're a supervisor of Ms. Yu, correct?
No, I'm not. I supervise Captain Novotny. Captain Novotny supervises Mary Yu.
Okay. Is that just somehow different than what I said?
Yes, you said, am I a supervisor of Mary Yu?
Okay. And the distinction there is, in fact, you supervise her supervisor, right?
Correct. I don't have any day-to-day supervision over Mary Yu.
I got it. So, but you don't have any reason to dispute that that happened on the 15th. So again, this internal affairs interview, that would have been 12 days before the county is compiling documents on his ERD complaint. And then 13 days before they terminate him, right?
No, no.
Well, it's also fair to say that if his internal affairs interview took place on September 3rd, then that occurred after you knew that he filed an ERD complaint, right?
Say that again?
If, in fact, his internal affairs investigation occurred on September 3rd, that would have happened after you learned that Mr. Lucky filed an ERD complaint, correct?
Well, his internal affairs investigation had to be open way before November or September 3rd, if that's the day of his interview.
I'll keep that in mind. Can you please answer my question?
That's what you said, the internal affairs investigation.
The internal affairs interview happened on September 3rd.
Right.
And that would have happened after you learned of Mr. Lucky's ERD complaint, correct?
After, yes, this entry of Mary's, which is August 31st, yes.
Okay. So therefore, because if the interview happened just on November or September 3rd, you would not have signed off on the completeness of the charges until after that, right?
The investigation was not over if the interview was still pending.
Right. Okay. So based on that, the answer is yes or something else?
I did not have the file on September 3rd.
Okay. And so this is also the internal affairs investigation happens probably 3 days after Mr. Lucky, or you are told by Miss that Mr. Lucky says that internal affairs cases were actually investigated, that he wouldn't have been suspended in the past. You see that?
Yeah, I do see that's what he told her, yep.
Okay. And she told you, right?
Again, I don't recall that conversation. If Mary testified that she covered all these things, I don't know if she covered all these, followed up with Molly in the conversation. I would ask her, and whatever she says, what she remembers would be the best evidence.
Okay. So when Mr. Lucky, after Mr. Lucky made this complaint, or after you learned that Mr. Lucky made this complaint about internal affairs, was there any steps taken to have somebody other than internal affairs investigate Mr. Lucky's complaint?
Again, I don't have an independent recollection of that time, but clearly I would say no, because IA investigated the case. Was there discussion regarding it? I don't recall.
Okay. But if Mr. Lucky is making that go to internal affairs and they're not fully actually investigating, and then he gets suspended, isn't that the same kind of thing that happened here with the Gladney incident?
I don't understand that question.
Okay. You'll agree with me that when Mr. Lucky made a complaint against Mr. Gladney to internal affairs, that you authorized an investigation into Mr. Lucky for recording Mr. Gladney's calling him a nigger and threatening to assault him, didn't you?
I don't recall what the claims were open on, but I believe there was one opened up against both of them. I think, but I don't recall.
And you authorized that.
You'd have to show me the investigation authorization document. I don't recall specifically what was in there from almost 2 years ago.
Okay. Do you see how it says on September 3rd of 2021 that Ms. Paul followed up with Lucky on the status of the complaint? You see that?
Yes.
Okay. And then it says informed him that IA must go through the investigation process. Do you see that?
Yep.
Okay. Why must IA go through the investigation process?
I don't recall about the specific steps of this investigation, and I don't know why Mary said that or what she meant by that.
Is that policy?
All serious allegations that are formal complaints are investigated by PSD. Yes, but I don't know
Right.
what she means by this. You'd have to ask her.
But Mary Paul has no control over internal affairs, does she?
No,
No, you do, don't you?
I supervise it.
Okay, so a decision that internal affairs must go through the investigation process, that's not Ms. Paul's decision, is it?
No,
It's your decision, isn't it?
yeah,
Yeah. And then you see where she says, and I will be reviewing as well?
yeah.
Yeah, okay. Now, she testified that she didn't actually review that. But.
Review what?
it said- Sorry?
Review what? You said review
She didn't
that.
actually review this Mr. Lucky's complaint here.
Okay.
Well, that's because she was told by you that HR was, or internal affairs is going to investigate. Isn't that right?
Right, like I said, a formal complaint goes through the investigative process by PSD.
Right. Okay. So when Ms. Paul, and she did admit that when she says that she will be reviewing it as well and told that to Mr. Lucky, that was false. Do you agree with that?
I don't know. I don't recall what, I don't know what she told you or what she said to him or.
Well, you agree that HR doesn't investigate anything, right?
I think HR does investigate certain things, but like I've said now for the third time, PSD, all formal complaints of rules violations, PSD investigates. That's why they exist.
Right. But in fact, Ms. Paul had no authority or ability to follow up on Mr. Lucky's complaint about Mr. Gladney threatening him and calling him nigger, did she?
Well, you'd have to ask them about that. We do our own investigations.
You're not aware of what she can and can't do, is that right?
Again, on formal complaints with rules violations, we investigate them.
Okay.
That's what
My
PSD
question to you was whether or not you were aware of whether HR could conduct its own investigation.
Are you saying in general or in this particular case?
We can start with this particular case and move to general if that's what you prefer.
I don't recall the conversation with Mary, but again, since we do investigate formal complaints of rules violations, we would investigate it and they would not investigate it.
And that's always the case, isn't it?
Yes.
Yes. Okay. And HR doesn't have the authority to interfere with an internal affairs investigation, does it?
Well, define the word interfere.
Is there any way that an HR can stop an internal affairs investigation from going forward?
I mean, in the past, that typically has never happened, but I mean, if there was a reason, we would discuss it. And
like you did here, right?
I don't recall discussing it. As I said,
You would discuss. That's what you believe your practice would be?
what Mary said. Yeah. She would let us know when they get HR complaints. If somebody goes right to HR as opposed to internal affairs or any other way that you could initiate a complaint.
Okay. Just here at the bottom, that Ms. Paul says that she reminded Mr. Lucky that we take all allegations seriously. Did you see that?
Yeah, that's what it says here.
Yeah, okay. And by we, she means the county, doesn't she?
Yeah, I don't know what she's saying.
Well, does the sheriff's office take all allegations of retaliation seriously?
We absolutely do.
Oh, okay. How did you take Mr. Lucky's allegations of retaliation seriously?
We take all allegations of discrimination, retaliation seriously.
Identify
As I've said
what
before,
actions you
as I
took
said,
to
as I said
take
before-
Mr. Lucky's claims of retaliation seriously.
as I said before, I don't recall the specifics about this case. But
Sitting here today, isn't it true that you can't point to any evidence whatsoever that would show that you took Mr. Lucky's claims of retaliation seriously? Can you?
as I've said, I don't recall the specifics of this case and the specifics of the investigation. So
Well, how are
that's
you able
what
to-
I keep saying to you.
So how are you able to sit there and say that the sheriff's department takes all claims of retaliation seriously? You can't even identify the steps of the case to respond to Mr. Lucky's claims of retaliation.
Because again, I don't recall the specifics of this case.
Okay, with that failure to recall in mind, how can you sit there today and tell us that the sheriff's department does not retaliate?
Because I understand how the PSD division works and how professional and unbiased and what a good job they do. And it's important to all of us that we maintain that integrity so we can do unbiased investigations.
So it's your testimony that you conduct unbiased investigations, is that right?
Absolutely. I don't conduct them. Those who work there conduct them.
The people you supervise conduct unbiased investigations, that's right, is that what you're saying?
Yes.
But you can't point to any evidence that would explain to us how they conduct unbiased investigations in this case, right?
I mean, generally how they handle cases, yes, but as I've said a million times, moving. This, I don't recall the specifics of this case.
And how do you know that they conduct unbiased investigations when the person who they're conducting a so-called unbiased investigation is alleging that they do not conduct unbiased investigations?
Well, I understand. I understand that. investigation. I understand that. I understand that's his position.
Okay. And what steps did you take in response to that position, if you can recall any at all?
Like I said, I don't recall sitting here. The person with that direct knowledge, of course, would be the person who conducted the investigation.
You'll agree that it's hard to maintain a position that something can't happen and maintain a position that you can't recall any facts that would support your position. Right?
Objection, compound, vague, argumentative, and asked and answered.
Go ahead and split up the question and see if she can answer.
Okay. So you'll agree that when you say that you can't remember any facts about Mr. Lucky's case or any steps that you took to resolve his accusations of bias, that makes it difficult to support your contention that there is no bias in the department that you supervise.
I disagree with that. The whole purpose of the PSD division is to do unbiased, professionally trained internal workplace investigations. We would hardly be able to put on cases in front of the PRB where body hears evidence of cases and looks at them themselves and, you know, successfully prosecute these cases if our investigations were as flawed as what you're saying. I don't remember the specifics of this, but my point is this group, PSD, is trained to be professional. They're trained to know how to investigate. They're trained to look at things that are brought to them. So that's why I'm saying that.
So correct me if I'm wrong, but what I understood you to say was that because the PRB sustains charges that you file, that therefore you're not biased. Is that what I understand?
No, I'm just saying it would be hard to maintain credibility and present cases that aren't well investigated, documented, and prepared.
And this is the same PRB that you participate in the removal of the president and vice president, right?
Objection.
I mean, seriously.
Sustained.
Rule then, Ms. Your Honor.
Sustained. It's sustained.
Are.
We all see how they walked right into that one, didn't we? She can't say that the PRB is the touchstone of her not being biased.
I didn't say that. I went through the whole process of PSD and what they do and ultimately where it goes. It can go even further. The circuit court, they look at cases on certiorari. I mean, the point is that we do independent, professional, well done, not biased investigations so we can get to the truth and be able to have a case that's based in law and fact. The PRB is just.
And these are the same cases which it's not possible to discuss retaliation or any basis for retaliation because you're only focused on the facts of what happened, right?
Objection, vague.
What's the same PRB that you didn't tell that Mr. Lucky filed an ERD complaint, isn't it?
I was not involved in that case. I didn't put that case on. I don't know what was told to the PRB or not. I don't recall.
In the,
So I can't
okay.
answer that.
So, but you did sign a document
Yes, I
for
did sign it.
completeness that went to the PRB, right?
No, I didn't sign
And you're saying you're
anything.
not involved in it based on that,
I
that means
didn't,
you're not involved in it?
I didn't sign anything and I didn't say I wasn't involved in it. But I don't do the PRB hearing, so I wouldn't have told the PRB anything is what I'm saying.
Okay, but again, your department interviewed Mr. Lucky, came up with a summary, recommended that to you. You reviewed it for spelling and completeness and signed off on it and went to the chief deputy, right?
I don't recall what was contained in that investigation as to, you know, credibility and who said what. I don't recall the investigation, so I can't possibly answer your question that you want me to answer when I don't recall it.
Okay. So if you don't tell the ERD or the PRB about the fact that, for example, Mr. Lucky filed an ERD complaint and alleged that internal affairs investigations are biased, how is it that the PRB is able to review your decision on, for example, not being biased?
I have no, you have to ask that question again.
Okay, because the problem is that you're saying that we're not biased because we're professional and we're thorough and it goes through the PRB and the PRB ratifies our decision.
No, I didn't say they ratify a decision. They make their own decision.
Why did you cite the PRB in relation to my question about how you knew that the Sheriff's Department could not be biased in its investigation?
The PRB is but one potential court body. It could be the WERC also, who independently hears these cases. They look at all the evidence. They listen to Deputy Lucky testify. They listen to the PSD people testify, and they make their own decision.
Without the benefit of the fact that Mr. Lucky filed an ERD complaint, right?
Again, I don't know if that information was part of the PRB hearing or not.
Well, you know it wasn't there when you signed off on it, right?
I don't recall what was in the entire investigative file.
Well, you did tell us, did you not, that the only thing that matters for that completeness is whether or not there was the fact that he committed the alleged infraction, right?
No, I was saying that when the case is investigated as to those specific allegations. And that was the Freighter case.
And that's when I asked you whether or not it would have made the investigation report more complete had you included the fact that Mr. Lucky alleged race discrimination, retaliation, and filed an ERD complaint.
And again, I don't recall if that was in there or not. And I can't testify whether or not it would have mattered.
No, well, you're the expert on completeness, right?
I didn't say that.
Who else's job at the Sheriff's Department is it to review internal affairs investigations for completeness before they go to the chief deputy?
It starts with Captain Novotny, then it goes to me, and then it goes to the chief deputy.
Okay. And again, your job is to review it for completeness, correct?
Yeah.
Yeah, okay. So based on that knowledge and expertise, and you're good at your job, right?
Absolutely.
Okay. So with that knowledge in mind, can you tell us how an investigation summary can be complete without this information, the complaints of race discrimination, retaliation, and the fact that Mr. Lucky filed an ERG complaint?
Well, all I can say again is when you're looking at a case that has been investigated, you're investigating facts of the case before you. Okay?
Okay.
So,
And you'll admit
and those
that some of the
cases, and those cases are investigated based upon the facts presented in that case. That Freighter case is separate and apart from the other case. And I can't recall if Deputy Lucky wrote anything about that in his case review. I don't know. I don't know if he brought it up at the PRB. It's not necessarily relevant to his particular case before the sheriff on the facts of the case that was being investigated.
Okay, I appreciate that, and I think we're almost done. So, we have already covered around here, have we not? That at that time,
Can you say that again?
we covered, yes, absolutely. We covered this ground before, that at the time that you signed off on this complaint for completeness, that you had, of the facts that you had before you, was that Mr. Lucky filed race discrimination complaints, that he complained about retaliation from internal affairs, and that he had filed an ERG complaint, right?
Again, I don't recall that. I know what Mary's notes say, followed up with Molly on the conversation. If, you know, again, she's the person you should probably talk to about if every single one of these things was covered during this conversation, not me, because I don't recall.
I'll keep that in mind for future reference. Now, because you never discussed this with the chief deputy, it's fair to say that you're the one who made the decision that Mr. Lucky's ERD complaint, race discrimination complaints, and complaints of retaliation were not relevant to the Freighter Hospital matter, right?
I don't recall having a conversation with the chief deputy of this. And I don't recall anything else about what you just mentioned about making a decision either way.
Well, we know based on this document that you had this knowledge when you made this decision to sign off on the investigation for completeness, don't we?
Objection, Your Honor. Asked and answered so many times by now. Can we please move on?
You can answer the question if you're able to. If you're not, then you may say so.
I mean, I can't answer it any other way than I already have 20 different times.
Thank you.
Sitting here today, can you point to anybody else who made the decision whether or not Mr. Lucky's discrimination complaints, retaliation complaints, and the fact that he went to the ERD and complained of race and discrimination and retaliation were not relevant to the Freighter Hospital allegations?
I'm not, okay. Again, I think it's a mischaracterization of what I said.
Well, first, can you answer my question, and then I'll ask you why you think that's the case.
Again, Captain Novotny reviews a case, I review a case, and the chief deputy reviews a case. And then the sheriff ultimately reviews the case.
And I know we've been over this, so I'll just be clear though.
PRB ultimately reviews a case.
And it doesn't say that Ms. Paul followed up with the PRB Sheriff Lucas, Chief Deputy Ball, or Mr. Novotny. It says she followed up with you, doesn't it?
Yeah,
So you were the gatekeeper at the Sheriff's Department of that information, were you not?
I don't know who else knew.
Oh, okay. So it's fair to say that at least you were the gatekeeper of that information, right?
I mean, I don't recall any of this conversation with Mary. So you have to take what this says for what it says.
And you've already told us that you think this is the best evidence, right?
Right, and it says follow up with Molly in the conversation. So it doesn't say I discuss every one of these bullet points. I can't say what, ask Mary.
Okay, no more questions.
All right, Attorney Lawrence.
Thank you, Your Honor. Ms. Zillig, is reviewing IA cases the only thing you do in your job?
Absolutely not. It's one of many, many, many things I do on a daily basis.
If you had to assign a percentage to it, what would you guess is the percentage of time you spend reviewing IA cases for completeness?
A very small amount, I suppose.
About how many times a day do you think you speak with Mary Paul?
About all HR matters or about IA cases?
Just in general. How many times generally a day do you think you speak with her?
Anywhere between, for sure, 1 and maybe 5.
And how many emails a day do you think you get from Mary Paul?
On average, I probably get between 20 and 30 a week, I would guess.
Okay. When you say that you sign off on an investigation for completeness, what do you mean by that? What are you looking for in it and determining it's complete?
I'm not reinvestigating the case or determining if an investigator has every little thing in an investigation that possibly could be within the realm of an investigation. I look at it to make sure that all the people who are like in an investigative brief, all the potential witnesses, that their testimony was briefed as what it says in there into the investigative brief so that it lines up. I'm looking at the potential rules violations as it relates to what the investigator found to see if those are the potential correct rules violations. I'm looking for punctuation. I'm looking for grammar. That's pretty much what I'm doing.
Thank you, Ms. Zillig. When you're reviewing an IA investigation, do you believe it's, as a general matter, would it be appropriate to stop an IA investigation because of a filing of an unrelated ERD charge?
No, it's not.
And why is that?
Well, we're looking at a completely different matter. And we're just determining the facts of that particular. And we're making sure that the facts of the case that were
I got
brought
the
to.
what just happened?
We just got some feedback from somewhere.
Sorry, what was the question?
I think actually she was done answering it.
Okay, I apologize for interrupting, but that totally threw me off.
I think it came with it. Were you done answering, Ms. Zillig?
Yes.
Okay. I apologize for the feedback on my end. if I told you that September 18th, 2021 call that Counsel Attorney Hitchcock Cross was referring to consisted of you, James Novotny, Mary Paul, and Doug Holton, would that give you any clue as to what Mr. Lucky's assignment was at that time?
Well, I'm assuming courts. I mean, Doug Holton was on the call and he was in charge of courts at the time.
Would that lead you to believe that Deputy Lucky or James Lucky was assigned to the courts division at that time?
If Doug Holton was on the call, that would make sense.
And I think you testified that Frederick Gladney was a sergeant on patrol at that point in time, correct?
Yes.
As you sit here today, do you recall any of the basis for which Fred Gladney was disciplined?
I really don't.
Is there anything else that you think this hearing officer needs to be aware of in deciding this matter, Ms. Zillig?
No, I can't think of anything.
Okay. I have no further questions. Thank you.
All right, any redirect? Attorney Cross?
Thank you. I just want to be clear, when you are reviewing decisions for the investigations, another one of the things that you're looking at is to protect the county from liability, right?
Not when I'm reviewing investigations. I'm reviewing investigations to make sure they're complete and fair and unbiased.
And correct me if I'm wrong, but I understood you to say that you were always making sure, watching out to protect the county from liability. Did I misunderstand that?
Right, but that doesn't mean that sometimes there's problems that you have to deal with. That doesn't mean that what you're insinuating it to be.
What am I insinuating?
As the chief legal and compliance officer, the hope is to reduce risk and legal issues, obviously, for the sheriff's office. That's the whole point.
Okay.
But like I said, internal affairs exists to have fair, unbiased investigations that are done by competent investigators. So.
Great. What happened to the investigation into Mr. Lucky's complaints about race retaliation after he was walked out of the sheriff's department?
I do not recall.
Were they continued or something else?
I don't recall.
Okay, based on your knowledge of policy and procedure, what would the policy have been after Mr. Lucky had been walked out? Would his complaints been continued to have been investigated or something else?
His discrimination, harassment complaint?
Right, against internal affairs. Let's just start with that. What would the status of his internal affairs been, complaints been after he was walked out?
I believe his case still continued because I think he's making allegations against Gladney, and you said he got a 10-day suspension.
Okay, did Mr. Novotny get a 10-day suspension?
Did what?
Mr. Novotny get a 10-day suspension?
Objection foundation.
Well, you would know if Mr. Novotny was being investigated, wouldn't you?
No, Mr. Novotny was not being investigated.
Okay, and you know that, don't you?
I'd remember that.
Okay, well, that's something.
I
So
know.
keeping that in mind, it's fair to say that there was no investigation after Mr. Lucky was walked out into his allegations, that every time he makes a complaint to internal affairs, he gets investigated.
Objection compound.
Can you split it up, Mr. Cross,
Sure.
please?
So based on your knowledge that Mr. Novotny was never investigated, it's fair to say that the investigation into Mr. Lucky's allegations stopped, right?
Which allegations are you talking?
His allegations against the internal affairs for retaliation.
There was no internal affairs investigation done regarding whatever his complaints were about PSD.
Okay. And wasn't that convenient that he got terminated?
I wouldn't say it's convenient. That's, if you're going to say that, I would disagree with that.
Well, your subordinate didn't get investigated, did he?
He did not.
Until today, you've never had to answer questions about whether or not you knew about Mr. Lucky's ERD complaint, the allegations of race discrimination, and the allegations of retaliation by your internal affairs division before you sent it to the chief deputy. Did you?
Objection compound. And asked and answered.
What's the compound there?
You cited 3 different things.
The race discrimination,
The alleged race discrimination claim after the filing of his complaint, the alleged retaliation complaint made after the filing of his complaint, and the ERD complaint.
great. So with all those, appreciate that guidance. Thank you very much, Ms. Lawrence. With that in mind, can you please answer those questions in that order?
I can't even, I have no idea what you're even asking. Maybe the judge understands it better than me and she can repeat it.
Well, I think he was asking if you've ever had to answer any questions about what happened to Mr. Lucky's complaints after he was discharged.
I don't recall having any conversations about it.
Not until today, right?
I believe so.
And if it wasn't for the existence of Ms. Paul's notes, you may never have had those conversations, would you?
I don't know how to answer that. Maybe.
Well, you read the order, didn't you?
I did read the order.
Can you answer my question, please?
The order was about the conversation, the meeting we had with Mary Paul on whatever date that was. Those other notes, I believe they're not up anymore from the 31st. So I still don't recall what we discussed with Mary Paul on the 18th independently, but I thought those notes were from the 31st. So.
And you know that those notes were not given to Mr. Lucky at any time in discovery, don't you?
Objection foundation.
I'll just ask her if she knows whether or not they were discovered during discovery.
I just asked that, were they produced at any time during discovery?
I'm guessing not. I don't represent myself in this lawsuit, so I'm thinking that's part of the reason why we're back here today. So.
Okay. So that was also convenient for you not having to answer. The fact that those notes were not disclosed in discovery was also convenient for the fact of you not having to answer these questions until today, right?
Your Honor, if I may, this is not only argumentative, but it is assuming facts and evidence, and contrary to your order, we've already determined that these weren't requested in discovery. So,
Guy is green, Judge.
All right,
according to Attorney Hitchcock Cross.
okay. I think we're reaching the end of this witness, are we not, Mr. Cross?
Sorry, but what she asked, though, and let's not just fall there, is she's asking you to say that that because there was an order out there, that you should then turn off your brain, and that this witness cannot give us the truth in her answer. That, I submit, is evidence of a priori decision-making on discovery. And I think it needs to be pointed out here. But I do agree, and we'll be happy to wrap this up here and ask no more questions, because I think the point has been made and everybody understands each other now.
Thank you. Any
We had a Scooby-Doo moment here.
recross?
No, Your Honor.
Okay. All right, then, Ms. Zillig, thank you very much for your testimony today. It's appreciated. You may leave if you wish. Okay, we are at 4:34. Mr. Smoot had been in my waiting room, but he is no longer. Is it our plan to continue going forward today, or are we done for today?
I can absolutely stop. I think we'd be pressing it here.
Okay, is that going to be a problem with Mr. Smoot being available tomorrow?
Well, I think I would start, Your Honor, with recalling Mr. Smoot. In your order, Mr. Smoot was not among the people listed for recall.
Right.
He's already testified extensively on all of this. At the end of which you ruled that it's irrelevant to the complaint before you. So I think it's a waste of time. I don't think it's within the scope of the order, and I think that he's already had his crack at questioning Mr. Smoot.
So careful readers of the order might note that, in fact, what it says is that you believe that the only people who are relevant are, I think, Mr. Novotny and Ms. Zillig. Now, I don't know how you came to that conclusion, but leaving that aside for the time being here, the evidence and Ms. Zillig kept pointing out that we need to ask the investigator, ask the investigator, ask the investigator. Well, that's Mr. Smoot. So that's the reason why all this question came in. And I don't believe Mr. Smoot's going to take very long, but we do need to know, based on this Mary Paul notes and the fact that this investigation's ongoing, and particularly the issue with the attorney here, the fact that he can't get an attorney from the union, and that they all seem to know that. So those are the limited things that I need to get in on with him. And I don't anticipate it being very long, but again, Ms. Zillig, more than anybody, opened that door.
Well, I mean, I do see that Lieutenant Smoot was mentioned in Ms. Paul's notes, not to any great degree. I mean, I'm inclined to have his testimony taken for a complete record to be made. But I understand the realities of the work environment there. Is he available this afternoon yet? Is he going to be available tomorrow?
We are checking on both those things. And while we wait for that answer, Your Honor, can we take up the issue of Mary Sawchek's availability tomorrow? She is, last I contacted her, since she didn't have notice last week, she is only available tomorrow between 8 a.m. and 10 a.m.
I appreciate that. So in my mind, I think we were starting at 9. And if that's the case, I don't anticipate that being very long, but maybe if we started at 9, that would solve that problem. An
You have
hour.
1 hour with her? I have no objection to that.
I have no
Okay.
objection to starting at 9, so we can
And
start at 9.
my plan for Mr. Smoot is, sub 15 minutes here, so I just like to keep him sort of on standby to fill in a spot if we have that. I mean, I understand he's got other things to do, but he is being paid all the time here. But are we okay with, so we're set with 9 tomorrow?
I am.
That's fine.
Okay.
Okay.
And I have heard that Mr. Smoot, or, Captain Smoot is available tomorrow.
Okay.
Okay.
And is he a first shift? So yeah, he's an investigator, so he works normal hours.
He's
Okay.
no longer an investigator, Your Honor, but he
Oh.
is a first shift.
Okay.
Are you kidding? Hey. All the petals fell off my tulips too, so I guess the world changes.
All right. Anything else that we need to address before we adjourn today?
Well, if we want to take up one last thing before we adjourn, there's the matter of my subpoena. I would actually motion to quash that as wholly irrelevant and inappropriate.
Oh, you've been subpoenaed personally?
I have been.
Okay.
Yep.
And what is the purpose of that?
Well, it's relevant because we need to get her testimony on why the county was asking for these records on the day before they walked Mr. Lucky out. So we have evidence, and also from Ms. Paul, that she talked to Ms. Lawrence about the ERD complaint. And we've got this email here from Ms. Lawrence asking for the ERD information. So we need to know, apparently that was all part of the proximity and decision-making, the atmosphere that's going on here, and allow us to indirectly prove that the ERD complaint is a motivation for walking Mr. Lucky out.
And I think if we look at the testimony from January 26th, we will see that that whole chain is covered in detail by Mary Paul's testimony. She testified that she emailed notes to Mary Yu, who emailed them to myself and my paralegal in response to our request for records.
And that is my recollection as well.
I think there's a full transcript on that.
Yeah, I'm sorry, Mr. Cross, but I am not going to make Miss Lawrence become a witness in this matter. I just don't think her testimony is needed to prove what you've said. It is entitled, or it's needed to prove. We do have Miss Paul's testimony, and I think that's enough.
I appreciate that. I also want to bring in the other point here, which is a separate, I guess, argument. I'm sorry I didn't make this before, but to the extent that the motion to the discovery response says that their failure to produce that was inadvertent, that's all the testimony from Ms. Lawrence. So that's also one of the reasons that we believe that Ms. Lawrence's testimony is valuable and relevant here, again, because she's apparently participating in this decision to get information upon this is the really important part is the corporation counsel being involved in this decision here, and why is the fact that he's being walked out the day after they're getting these ERD records. So I know we've got evidence saying that they were asked for them, but again, we also, and I can go here on the transcript. Oh, it's an AST. So Ms. Bell identifies it as Miss Lawrence's request, and that she said that she gave her a copy of her notes. You contain a folder. What other documents are contained in that folder? A copy of the complaint, the one that I sent upon attorney's request, Lawrence's request, shortly after providing this one. Okay, so she's talking about the HR complaint, and that she's also sent that to Ms. Yu in response to Ms. Lawrence's request. This is, again, we are submitting here that the gathering of documents for in response to Mr. Lucky's ERD complaint is directly related to the termination. And as we just went through with Ms. Zillig, it's quite convenient for the county because what we submit is pretextual reason for walking him out, short circuits all of his terms and conditions complaints. And Ms. Lawrence here is a indispensable witness for the question of why, and she's apparently participating in the gathering of these documents that then are being shared again with Ms. Zillig. We submit that that's ratcheting up another notch, and the next thing that happens that we have any evidence for is the decision to terminate, and Mr. Lucky is withdrawn. So thank you for allowing me to make my record on that. But that's, again, why we believe, I definitely understand and don't subpoena a fellow attorney lightly, keeping involved Gonzalez, Villarreal, that decision in mind. Here, we believe that she's indispensable, and that's why we subpoenaed her and making this argument here today.
Okay.
Your Honor, if I may respond.
Yes, please.
So to start, counsel's speculation that there's any connection between corporation counsel's gathering of documents to present a defense in the ERD matter has no basis in facts. There's more evidence in this record of what that process is, including Ms. Zillig's testimony today. And corporation counsel, the whole office of corporation counsel, has no part in that process. So any claim that he's trying to establish one is pure speculation, and once again, a total fishing expedition, which LURC has advised against. Second, in terms of sharing documents with Ms. Zillig, again, there's no foundation in fact for that. The request is made the day before Mr. Lucky is walked out. There's not even evidence that the request was fulfilled that day. And most importantly, all of this would go to a clear attorney-client communication and putting together a defense to the matter that is before you today. It would be highly inappropriate to have me testify, and all of Attorney Hitchcock-Cross's alleged reasons are based on pure speculation on his part.
I just have one additional point for the record. She just said that the corporation counsel has no part in this. And again, that just underscores the reason why we need evidence on this and not just her assertion like it was unintentional that we didn't give out the Mary Paul notes.
Again, I would like to, you're misquoting the record again. It was not unintentional. We argued that it was not requested. It was not requested. Please stop misstating the record. And again, you don't get to go fishing. You have to have evidence. If there's evidence that we were involved, perhaps this should be an issue, but there is none. You're making it up.
So propinquity is evidence. I could go on for hours about the difference between indirect and direct evidence and what's required in the direct method and why that's beneficial to employees and why that's required, and of it it's required is because employers don't go around telling employees that their reasons for doing things. Again, we found that out here, but for the Mary Paul notes that they didn't give us, we wouldn't know what that was actually going on. And they kept hiding behind that, as we saw before, when they said, well, why didn't you go raise this issue before? Well, why didn't you give it to us? But I understand that that issue has been litigated. My point here again is that we can see by her sneaking in testimony that she's only proving my point that she is an indispensable witness for why exactly, and our ability to prove that the fact that he filed an ERD complaint, but for, let's put it like that, but for him filing an ERD complaint, he would not have been terminated. And so, but for, we think the conglomeration of these documents that again were not shared with the person who made the decision that day, and that's part of the issue. So again, the Mary Paul notes, the issues that are in the fact that we didn't get them, coupled with the fact here that she's saying that affirmatively testifying that her office plays no part in this process, is just underscores my point that we need to know what role they do play.
Your Honor, if I may correct the record, I'm not sneaking in testimony. I'm pointing out, I'm making a commentary on the record that there is no evidence on this record that we are involved. And he doesn't get to go fishing without evidence that it would be relevant. I mean, it's really gone too far in this whole case that he's just allowed to explore. I mean, we wouldn't be this far afield if you weren't allowed to conduct discovery as a hearing.
Okay, well, I am going to quash the subpoena, and you can take that up with Lurk and whomever. But I am not going to turn Miss Lawrence into a witness.
Thank you, Your Honor.
All right, anything else?
No, have a great day. See you at 9.
Okay, 9 o'clock it is.
Thank you, everybody.
Thank you.
Bye.